The broadcast is now starting. All attendees are in listen-only mode.
Hi all, welcome to the second webinar on this topic. Time flies, doesn't it? This was 7 months ago we did the first one. I'm reliably informed by Ed that 3 of our attendees from the first webinar have backed up for this webinar. My apologies to you if you heard it all before. Nothing much has changed in relation to the method of enforcing a lockout. Also, my apologies. At our last webinar, I indicated that this presentation would be on our website. Technical difficulties didn't enable us to do that, and I'm also reliably informed by Ed from our office that this presentation will go onto our webpage. So please have a look at that, but allow a day or so after this has been given before you try and check it out. We've had a good response to this webinar with registrants coming from far and wide. There's only 17 actually listening here at the moment. We expect that a few more might join in as they pick up their lunch and grab their cup of coffee. I'd like to welcome our registrants from Cairns, Toowoomba, Nambour, Townsville, Gold Coast, Caloundra, Surfers Paradise, and of course our locals. The seminar today is, or webinar today, is in relation to when can we lock them out. I'm your presenter, and that's a very unflattering shot of me, but that's who I am. I've been doing this sort of work for a long time, and I have gleaned some experience in relation to the topic at hand, and hopefully I can assist you this afternoon. As always, there is a disclaimer to let you know that the information we give today is general legal advice only. And you should take specific legal advice on any matter that arises as a result of information given in this webinar. Now, the format will be similar to last time. As I talk, if you have a question, jot it down and send it through, and I will attempt to address it in the time I have at my disposal, or I'll contact you after the webinar to discuss it if we run out of time. Also throughout the webinar, like I did last time, I will seek your cooperation to answer some poll questions which are very relevant to the topic we're discussing today. The ability to lock out a tenant will depend on the individual circumstances of the case, the documentation executed by the landlord and the tenant, and the validity of the notice to remedy breach, if that applies, or the abandonment of the premises by the tenant. What we have up on the screen for you at the moment is the REIQ Commercial Tenancy Agreement. It is a very well drafted document, but it has limited application. You must look at its suitability for each circumstance. Read and understand the instructions to complete. If you go down the track of the ADL contract for commercial tenancy agreement, same thing applies. You cannot use this document for a residential tenancy agreement, for premises covered by the Retail Shop Leases Act, where the term of the lease, including options, exceeds 3 years, or where registration under the Land Title Act is requested by the tenant. In my experience, in most commercial tenancy agreements, they do go longer than 3 years when you take into account option provisions. Therefore, you will find in most situations that your landlord will be asking his solicitor to prepare a lease which is capable of registration at the Department of Natural Resources and Mines. That will also be the request of most tenants. This webinar today is directed at Commercial Tenancy Agreement REIQ. However, you must understand that in a lot of circumstances, the situation will be that we are dealing with a Form 7 lease which is registered in the Department of Natural Resources and Mines. Having said that, there are many excellent clauses in the Commercial Tenancy Agreement, and there is some drafting that we've done for special conditions, which we give you the licence to use on the basis that it's used to suit the commercial tenancy arrangement in place. For example, if someone wants to enter into a commercial tenancy agreement for 2 years in relation to an industrial shed, by all means use this. For that same industrial shed, if someone wants a 2-year lease with a 3-year option, don't use it. It's as simple as that. In the commercial tenancy agreement, which we've got here in front of us today, the situation is that we've deliberately used the name of a company as trustee of a trust to be the lessor. The reason that we have done that is because there is a total misunderstanding and misconception about what a legal entity is, in the sense that a trust is not a legal entity. A business name is not a legal entity. Someone acts as trustee of that trust, or someone owns that legal entity. That person will be either the lessor or the tenant, depending on the circumstances. In this situation here, I'm just going forward to slide 10, I hope. I am. And in this slide, I'm showing you that the lessor for the purposes of the lease is Lucky Holdings Pty Ltd, with its ACN number, which you must put in. Sometimes you put in an ABN, that's even better. As trustee for the Lucky Holdings Investment Trust, trading as Lucky Commercial Property Investments. That says it all. The people who are able to sign on behalf of the lessor are the directors of Lucky Holdings Pty Ltd, and we'll come back to that in a minute. One of the biggest banes of my job is looking at documents that are incomplete, which potentially gives the ability for a tenant to wheedle out of their obligations with the landlord. It is important that if there is provision in an item schedule for information, that you complete it properly. So on this one, in item 1, you'll see we haven't put in the ABN because we don't have one. Put it in. In relation to the tenant, we can see that we might have some problems with this tenant with a name like that, but we've put in the fact that it is a company with its ACN, with its address, with its phone number, with its fax number, with a mobile number, with the ABN, with the email. Please complete everything. I guess at this stage people are sitting there scratching their heads saying, what's this got to do with when can we lock them out? As I said earlier, your ability to lock somebody out is going to depend on the documentation that has been signed by both parties. If the documentation is incorrectly signed, incorrectly put together, or doesn't exist, then the job to lock somebody out is eminently more difficult. In the premises, if shop 1 is one of, say, 2 shops, both being, so let's say it's an accountant and a lawyer, neither of which are retail shop leases, and shop 1 is the one being leased. If you describe it as shop 1, 140 Business Street, Fakelands, and don't put in the real property description and don't put in a sketch plan, there's a chance that the court could say the premises are not adequately described. For argument's sake, shop 1 might be 150 square metres for the lawyer and shop 2 might be 60 square metres for the accountant. And let's say, for argument's sake, someone put the numbers back to front. All of a sudden, you're trying to sue the lawyer or the accountant on the basis they own 60 square metres as opposed to 150 or vice versa. So the simple thing to do is to describe it adequately as the shop number, but also describe the full lot on plan description and annex a plan. Now, one of the drafting problems with this document, in my view, is it says annex the plan if available. I'm saying to you, annex the plan because it is necessary, and you must be able to define the premises clearly, otherwise you won't be able to issue a notice to remedy breach of covenant because it pertains to premises. What are the premises? Think that one through. Term, important that you set it out years and months, when it commences, when it ends. If there's no option, put in not applicable. In the rent, put in whether it's going to be per month or per year. Item 7, if there's a review date, put it in. Permitted use, important. Describe exactly what the use is. Chapeau and socks manufacturing. Okay, I don't think there'll be too many shops around doing that. It's manufacturing, so it's not a retail shop lease, before anybody asks me that question. If there are outgoings payable by the tenant, put in the percentage. If a deposit's required to be paid, put it in. Then the next one is also the bane of a lot of leases that I see, is that you good people as agents don't sell yourself well enough. Put in all your details, everything, including your licence number and your mobile number. We haven't done that here because we don't know what the licence number is or the mobile number is, but put it in. You can't put enough information into a document. In every lease, there will be special conditions because the standard terms and conditions of a commercial lease, whilst, as I said, they're excellently drafted and they have very good clauses. However, we needed to put special conditions in this particular lease because we couldn't fit the information into the lessor's details, and there was an arrangement for a deposit and rent to be paid in advance, and that's been detailed in special conditions 1 and 2. Also, in this particular lease, there's a rent-free period. The drafting of this is a very simple but effective clause for rent-free periods. Even in smaller tenancies like the lawyer and the accountant sharing shop premises, shops 1 and 2, they might have to share toilet facilities and other common areas. So this is a very simple clause which does the job. No matter how small the tenancy might be, it is always a good idea for lessors to have rules and regulations, or to give them the ability to promulgate reasonable rules and regulations in relation to safety, care and cleanliness and comfort of people and closure of common areas and use of car park facilities, etc. Put this clause in if it applies. So know what you are leasing. Understand what you are leasing. Don't do it blindly. Don't draw up a lease when someone says, I want to lease my shop out, without having a look at the shop. Even in leases I do at the moment, where I'm obviously not the agent, I actually go on site and have a look at what's going on. I went recently over to Brendale to look at a new commercial building being built, which was fairly unique. And without making that trip over to Brendale, the drafting of that document for me would have been fairly difficult. But by virtue of the fact that I took the time to go and have a look, it's a lot easier for me. Now, Lucky Holdings have got Jim Lucky and Mary Lucky as the directors. And it's a $2 company. Fair call, we need personal guarantees. What I've drafted here is a fairly simple, though effective, personal guarantee. One of the big things for tenants is that when they go to set up their accounting practice or their legal office or their manufacturing business, they want to go and move into their shop or move into their manufacturing shed and say, let's get cracking, I just want to manufacture my steel products, or I want to see my clients, or whatever it happens to be. At the end of the day, it is important that the landlord ensures that he gives a statement in the lease that there is no warranty concerning the suitability or exclusivity of those premises. So the tenant will acknowledge that no promise or representation has been made about the suitability of the premises or the business to be carried on, or that others might lease or continue to lease, and that the lessee has an exclusive or limited share right to carry on the type of business. This clause can be adapted to suit simple no warranty regarding suitability as opposed to suitability and exclusivity. Allow your tenant time to take advice. If you go along as the landlord's agent and you say to the lawyer, you can go into that shop one, there's no problem, it's zoned business frame or whatever it happens to be depending on what local authority you're in, he relies on that representation, goes in, there's no clause like this in the contract, and the council comes along and says, excuse me, this is a manufacturing area, you're not supposed to be here, and they kick him out, he'll have a shot at your landlord, who in turn will have a shot at you. Know your zoning. Know what goes where. If you're in doubt, ask. Check it out through the local authority. Check it out with the lawyer who's acting for the lessor. You're not the one who should be giving advice in relation to what can be done and what can't be done. If it's obvious and you know what the zoning is and you've been told by the landlord that's what it is, by all means go ahead. Execution. The devil's in the detail. And that is so true. That is so true. How many times do you get a commercial tenancy agreement where someone comes along and signs for the company, and then you find out that there are two directors? What you'd need to do in that case is prove that under Section 126 of Corporations Law that the director who signed had the ability to bind the company, and you'd probably get away with that. But why go through that drama if you don't have to? At the end of the day, the document calls out simply for a director, secretary and director to sign, And you need to know who the directors of the company are. And I'll come to that in a minute. You'll do what's called an ASIC search. And the same applies with the tenant. If it's an individual, then you go down to the OR part, which says Jim Reckler signs in his own name, and it gets witnessed by a witness with their address. Doesn't have to be a JP, has to be a person over the age of 18 years, simply to prove that Jim Reckler signed the document on that day. If you don't get it witnessed, that's not the end of the world, but it might be a little bit difficult proving that Jim Reckler did sign on that day and that's his signature. So why not go the extra yard and have someone witness it? Execution by tenant, same thing applies. Execution by guarantor. I mentioned in the last webinar that I did that I would prefer to see, if there is a guarantee in place, that it should be executed as a deed and that the commercial tenancy would be executed as a deed. And I'd be happy to talk after the webinar about that for people that want my advice on it. It's a pretty straightforward process to fix it up. Now, with the ASIC search, as I said, nice and simple. Here's ours, Cook and Hutchinson. You can go in and do that search. This is the front page of it. The next page will give you details of the directors and the shareholdings, etc. But from that search, you get a lot of information. You get the correct name of the landlord or the tenant. You get the ACN number, which I want you to put on every lease that you do. You get where the registered office of the place is, because that is important when you come to giving a notice of any description, whether it's a notice to remedy breach, whether it's a notice for something else. Any notice can be served at the registered office or at the principal place of business. So please take the effort of spending $20 odd to have the information correct. And if your landlord doesn't want to spend that, will you just tell him that, you might have dramas later on. If you do have those dramas, it will be your fault, not mine, because you've done your best you can. Standard conditions, who cares? It's standard. We don't worry about them. You should, because every one of those conditions says something and means something. They're not put in there to fill up the paper. They're there for a specific reason. Do yourself a favour and read them. I've taken a few out of those standard conditions so that you can see what they say. And you look at the text and the way that they're presented, they're very well worded and simple documents. Term and holding over is just so important. What happens if it's a 2-year lease and the lawyer who's got the 2-year lease in shop number 1 stays there and just continues to pay the rent? And someone comes along, the accountant decides, well, I need a bigger office. I'm prepared to pay you a bit more money. How do I get rid of the lawyer? Well, he's holding over, so you give him 1 month's notice, expiring on any day, under the standard commercial tenancy agreement. Some other leases don't say this. It depends on what's in the lease document you're dealing with. Use of the premises. If you don't put in a permitted use that is accurate, you could be in all sorts of strife as the agent. I used the analogy last time that if premises are described, permitted use as the sale of socks or haberdashery, I think I said, and someone's using it as a brothel, well, notice to remedy breach straight away, because the use is not what is described in the lease. And there's restrictions on use which are detailed in that slide. Default and termination. It sets out clearly in this document what amounts to an event of default by the tenant. If the rent's unpaid for 14 days, breaches any other term of the tenancy, assigns its property for the benefit of creditors, or becomes externally administered body corporate in the meaning of the corporations law, that is an event of default. And if the tenant does default and doesn't remedy the default, now I stress remedy the default because that's where I'm about to come from with this notice to remedy breach of covenant. You must give the tenant the ability to remedy the default. Then you can go and do all those things. You can't do it unless you give him the ability or her the ability or it the ability to remedy the default. Then you can go and re-enter and take possession, terminate the tenancy, convert it into a tenancy from month to month and do all those things. But you can't do it unless you give them the ability to rectify the default. End of term, what happens? Tenant's obligated to vacate, give back the premises to the lessor in good repair and condition and remove its property, repair any damage and return all keys. This has got nothing to do with locking them out, but this is why it's important that you have a security deposit or a bank guarantee in place in relation to most leases. What happens if I don't remove it? Well, the landlord can remove it and store it at the tenant's risk or can treat it as being abandoned. Be careful. If this clause isn't in the lease you're dealing with and the landlord treats it as being abandoned and goes and sells it without this clause being in the lease, there's conversion, there's damages, and there's potentially a breach of the criminal code. You'll be able to visit the landlord in jail. Now, if there is a default and you want to give a notice, basically what the standard commercial tenancy agreement is saying that any notice required to be given to any person under the agreement, it must be in writing and given in accordance with section 347 of the Property Law Act. Section 347, which is on the screen now, and I'll spend a minute talking about this because it's important. All well and good to get your notice to remedy breach correct, then don't serve it properly, allow you 30 days, then go and try and get possession. Tenant stays in there, writes back to you through his lawyer and says that the notice is invalid because it wasn't served properly. And there's case after case that says if it's not served properly, strictly in accordance with the Property Law Act and the terms of the lease, then it's invalid and you start again. You won't have a happy landlord. You can give it to them personally, you can leave it at the person's last or usual place of abode, or if it's a business, at the place of business, by posting it by registered mail. Given that registered mail is going to take, it's on the snail trail now, it's going to take a lot longer based on what's about to happen with Australia Post. If it's a corporation, by posting it as a letter addressed to it at its registered office or principal place of business. Hark back to what I just said before with the ASIC search. That information is there for you so that you can go and do that. If you don't know what the principal place of business, business is, or don't know what the registered office is, where you're going to serve it. So that's all very important. And then there's some deeming provisions about when it's deemed to be served, etc., etc. But this slide will be available to you at the end of the seminar, probably by tomorrow. So if you ever you're in doubt about anything, you can just come back and refer to that or call me here and I'll have to talk to you about it. Section 124 of the Property Law Act talks about restriction on and relief against forfeiture. That's a fancy way of saying, what can I do to get rid of the tenant? And you are restricted. You can't just turf them out. Section 124, which is up on the screen now, says a right of re-entry or forfeiture under any proviso or stipulation in the lease for a breach of any covenant, etc., 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 shall not be enforceable by action or otherwise unless and until the lessor serves on the lessee a notice, A, specifying the breach. B, if it's capable of remedy it. And C, where you're claiming compensation, require the lessee to pay the compensation. And it says the lessee fails within a reasonable time after notice to remedy the breach, then you can go in and do what you want to do. It's a three-pronged thing. It's not a one-pronged thing. And the notice to remedy breach must take into account those three things. I'll click over that. Okay, so here we've got notice to terminate the monthly tenancy of Recalcitrant Enterprises. I'll just click on again for this for a minute, just a sec. That's the format. You'll see it's got PLA Form 7 version 1 notice to remedy breach of covenant at the top of it. That's a statutory form. You must have all of what's there in the notice, and you must have those notes on the bottom. There was a case recently where someone forgot to put the additional note on the bottom and the court threw it out. Ridiculous, I know, but true, however. So that's the notice that we would give to Recalcitrant. Now, look at it very carefully and tell me whether it actually complies with all of the things that are necessary under Section 124. It says they're in breach. It says they owe $10,259.25, and it says there's an attachment Schedule A. We'll have a look at that in a minute. And it says that you must rectify within 30 days. Now, I use 30 days in all of my leases. I don't care if it's a week to week, month to month, payable 2 monthly, whatever. I give 30 days because most cases that have been decided by the courts say that that is always reasonable. In some circumstances, 21 might be, 14 might be. To err on the side of caution, I give 30. Now, there's our little additional note down the bottom there to make sure it's all okay. Here's Schedule A, and this takes a bit of time to put it together because there could be someone that's been in that tenancy, Mr. Lawyer, who's been there for 18 months, and he's been paying his rent spasmodically. He might have paid January, forgot February, paid a bit in March, missed in April, a bit more in May, missed in June, missed in July, paid some catch-up rent the next month. That has all got to be set out in the schedule so that who's ever getting the notice knows exactly what they've paid, when they've paid it, and what their arrears are. If you don't do that, your notice is defective and you'll get tossed out. Let's move on and get to the stage where we have actually delivered the notice, the time's expired, and they haven't moved out. What do? We're entitled to go to the premises, and we're entitled to effectively evict them if our notice is valid. If you go down and confront a tenant and the tenant says, I don't owe 10 grand, I owe 2, and they've written to you through their lawyer previously, don't even try to take possession because the tenant will put up a blue about the whole thing, and if it goes to court, there'll be order for costs made against the landlord. You next then need to instruct the solicitor to issue proceedings to get possession. And if you are going to change the locks, it's no point me telling you how to suck eggs here because you know how to do it. You go down after hours, change the locks, and then you'd put this notice on the front door or on the gate, depending on what it is, if it's commercial premises or industrial premises or whatever, inviting the tenant to contact a certain person to come and collect their plant and equipment. That's the best way to do it, and I know that there will be plenty of people I'm speaking to at the moment that have experiences where some have been nice and smooth and some haven't been. So it might be a good idea now, Ed's here to, we're going to conduct our little poll for a minute. So hoping you all haven't choked on your sandwich listening to this so far. Now the first question that we're putting up here, does it come up? It is up. No. Have you received instructions to evict a tenant in the past 12 months? We asked this last time and the response was fairly interesting. I'll give you about 30 seconds. %72% have voted, 28% have gone to sleep. No, 78%. Okay, 83% have voted, so we'll close the poll on that. Pretty much the same as last time. 73% say yes and 27% say no. Okay, well that's interesting. Next question will be, did you achieve a successful outcome? Okay, we're showing almost the same as last time as well, 82% yes and 18% no. I'll ask the next question now. For those that said yes, did the tenant go willingly? Only got 50% voted so far, but that'd be because some don't need to vote. Okay, we'll close that poll in about 2 seconds. Okay, so what we're saying there is that 58% said that the tenant went willingly and 50% said no. How does that work? Okay, 108%. Anyway, I'll ask the next question, might sort that out. If there was a lockout, was it pursuant to a court order or did the tenant vacate voluntarily? Okay, so those that it applies to said that it was a voluntary vacation. So no one's applied for a court order, so I won't ask the next question. We don't need to. Okay, thanks for that. That gives me an idea of what's going on out there. You all seem to be on top of your job. At the last webinar, we talked about retail shop lease tenancies, and we've decided that we're going to do a webinar. I'm just trying to find the date. I think we said the date. We'll send it out to you anyway, but it's going to be in late April. It'll be specific to retail shop tenancies. However, let's quickly look at the REIQ Retail Shop Tenancy Agreement. And remember, just read the warning. It doesn't apply to residential tenancies. If the premises are not a retail shop, then it doesn't apply to that either. If the term including options is greater than 3 years, don't use it. If either party requires the lease to be registered under the Land Title Act, and in my experience, retail shop leases, 90% of them do, don't use it. If the tenant is a major lessee as defined in the Retail Shop Leases Act, they wouldn't be signing one of these anyway. Then just have a look at the instructions to complete. They are very straightforward. The reference schedule, there's nothing remarkable in it. It's pretty similar to the commercial tenancy one. Again, make sure you put proper particulars in. In item 7, it just gives you a bit more space to put in shop numbers, name of centre and address, and a whole range of different things there, which we haven't completed properly. Don't complete it like this one, because you would have a shop number, a name of centre and an address, and you fill the whole thing out. And the area of the premises, etc., is just so important. And remember, in retail shop leases, we've got disclosure statements to go with the draft lease, and we can't sign a retail shop lease until the tenant's had the draft lease for a period of at least 7 days. And to get all the information for the disclosure statement, which, as I said, I'll talk about in a separate seminar, once you've got all that information, completing the lease is really a piece of pie. Also remember that in retail shop leases, that you must show how rent is to increase or otherwise on the rent review. You can't have CPI or 4%, whichever is the greater. You must stipulate exactly what it is. And you can't have a ratchet clause in it for the option terms. In other words, you can't say that irrespective of what market value might be, the tenant agrees to pay the rent paid in the last year of the original term plus 4%. You can't do that. That's illegal. Turnover rent, I don't think you'd be using the REIQ retail shop tenancy in respect of any premises where there was turnover rent. That normally applies to bigger operators like Coles and Woolworths and whoever. The outgoings, if there are outgoings to be paid in the disclosure statement before you give them the lease, you've got to give all the information, and you need to define it in this document as well. Retail shop leases are probably 3 times more difficult to prepare compared to a commercial tenancy agreement. I'm just going through these slides fairly quickly so as you can see what's up there. You will get these when you go to our website in the next day or so. Those special conditions aren't any different to the ones that we put in the commercial tenancy agreement, so there's no need to belabor the point there. And execution, fine. Standard conditions, again, I say read them. Have a look at the default provision here compared to the one in the Retail Shop Leases Act. Sorry, in the Commercial Tenancy Agreement. You need to read those, and you can see that they're different. we have to comply with that section if we're using that lease. You're going to find that the default provisions in retail shop leases can be, aren't always, but can be different to what they are in commercial tenancy agreements. There's a notice provision actually in the lease. At the end of the day, if no notice provision was put in the lease, then what you'd need to do is follow the notices as required under the Property Law Act. Okay, we had Ray White Commercial ask some key questions a while ago, and we thought it was a good idea to just talk about those quickly. And the question was, what are the 4 steps from breach to lockout? And the first one is to give notice to remedy the breach. If you don't give the notice to remedy the breach, you can't lock them out. You've got to give them the opportunity to remedy the breach. Once the notice expires and there is no possible defence to the breach and the tenant has not responded, the landlord is entitled to re-enter and take possession. As I said before, lockout should occur outside normal working hours for the sake of practicality. And lastly, the lockout notice should be displayed on the front door or the gate with a contact number for the tenant to make arrangements to remove their equipment if that applies. Is this different for retail tenants? Short answer is yes. It's governed by the Retail Shop Leases Act. The tenant may attempt to characterise the default as a dispute, and then you go through the process detailed in Part 8 of the Retail Shop Leases Act. In our view, if there is a genuine dispute, there's no difference in relation to giving notice to remedy breach of covenant as detailed in the answer to question 1. And there's our notice to remedy breach without the schedule attached to it. What should a breach include? I think you all know this. State clearly the nature of the breach. Allow a reasonable time, nothing less than 14 business days and generally a month, as I've already said. As commercial agents and property managers, which specific parts of the Act must we know? Retail Shop Leases Act. It's not that hard to read. Have a read of it. Sections 124 and 347 of the Property Law Act, as we covered today, and extracts of which are in this presentation. And the other question was, who has to pay for the costs of forwarding legal notices to the tenant? If the lease makes provision for the tenant to pay, most do, then the tenant has to pay. The problem is the tenant won't be paying the rent, he's not going to be paying for the notices either, so you have to get it from the landlord. Okay, I hope we're all still with us. The moral of the story, know your job and check the details. I'll just ask Ed if we've got any questions, and I'm happy to answer them, although we're just about run out of time here. Okay, there's no questions. Thank you for tolerating me for an hour. That's been a big job on your part. Okay, so where to from here? Any further questions? or if we can be of further assistance, you can contact me. That's my email address and telephone number. And I'll say sayonara until next time, and we'll let you know when the webinar's on for the Retail Shop Leases Act. Thank you for attending today. Bye.